Good morning, Mr. Davis.
Morning, Chief Justice Marshall.
We haven't even called it yet. I apologize.
SJC-10415, Commonwealth versus Hinds.
Good morning again.
Before I begin, there is a matter which is not small in scope, which could determine whether or not this appeal goes forward. Fortunately, on Wednesday night, the district attorney called me and alerted me to the fact that the appeal, the notice of appeal, was filed too late. It was, and I started to check and I found that that was so. What had happened, as I understand it, was that trial concluded in September of 2008, and disposition as to the murder convictions proposed immediately. However, there were two other indictments on which convictions have been returned, and disposition on those have been continued, eventually taking place in February of '09. And the trial counsel filed a notice of appeal in which he stated that final disposition was on February 2nd. So according to his notice of appeal, it would have been timely, but as I understand the rule, the time begins to run from the date of the imposition of sentence, and that's why, in effect, the notice of appeal from the murder convictions is not timely. So for the court's consideration, I have filed a motion with the clerk seeking leave to have the notice of appeal filed non-protunct.
The only untimely one is the murder one. Is that correct?
That's correct. The two murder convictions were untimely because sentence was imposed. I don't know how I missed that, but I did. And once again, I appreciate the courtesy of the district attorney in not throwing me under the bus and bringing it up here to you at the last minute.
I can ask Ms. Glant this, but Ms. Glant, did you file something?
I raised the issue in a footnote in my brief.
Oh, I'm sorry. I must have overlooked it.
I did too.
Okay. So that it's in the brief.
Yes.
Okay.
To Rule 14B at Commonwealth v. White.
Okay. Thank you.
Well, in any event, if I'm allowed to proceed, I must say that this is the second time this case is here, and both times it concerned the defense of insanity, and I am here to say that that's not why I'm here today. The charge on the issue of charge of mental impairment, I did not find any error, so it could not be raised. And my search of the transcript revealed one possibility concerning mental impairment. First of all, though, let me say that we recognize that mental impairment is not a mitigating factor which would warrant a reduction of murder to manslaughter, but...
Well, that's actually... I think the case you're relying on is it's an assault with intent to murder. So I'm not sure that that...
As I recall, I forget it, I cited it in my brief, but I thought it was murder. It was written by Justice Cordy, I believe, and I think, I don't know, I hope you're right, and not me, yeah.
I think it does.
But in any event, the issue as I see it now, and I have not found a case that speaks to this issue, and that is whether or not mental impairment can be considered on the issue of whether or not a person acts upon reasonable provocation. And I raise that as an issue because the testimony presented by the psychiatrist called by the defense clearly stated that a major mental illness, such as what he described as adjustment disorder, could have an effect on a person's perception. They may perceive threats because they have a debilitating belief that something is about to happen, or something is going to happen to them, that while this may be illogical and may be bizarre, that still a person suffering from this form of mental illness could entertain or harbor such a feeling. The facts of this case,
So the consequence of what you'd be asking us to do would be to eliminate the reasonable provocation, wouldn't it?
no, just ask that be considered.
Well, it makes reasonable not objective, but
But subjective becomes subjective for each individual situation.
It becomes subjective to that individual, but it would be objective from the point of view as could that happen to a reasonable person if he's.
But don't we consider it, because one of the prongs of the analysis is what was the defendant himself thinking? So we consider it on that part of the analysis, but not on what the reasonable person would do.
Yeah. Well, are we saying that a person who is ill is not a reasonable person, and that may be very well true? I don't think, if that is the conclusion we reached, this defendant was not a reasonable person. The facts of the case clearly show that he was not. This man had a lifelong fear of his brother. Things happened over the course of years that he pointed to in his testimony, which, in his opinion, justified his feeling. Things happened to him that were committed by his brother just shortly before this incident. He was afraid, and so he went to the court and got a restraining order, the temporary restraining order, and when he sought to extend it, there was a hearing which, in my view, was clearly, the reason was clearly misunderstood by the judge. The defendant had been threatened. As a matter of fact, he told the judge, that's why I'm
Threatened
here.
Of eviction.
No, that's it, no.
Isn't that what he testified to before the judge?
No, he testified that, yeah, they wanted to get he and his mother out of the house, yes, but that was not the reason for his seeking the restraining order. That's what the judge perceived that he was talking about, and that's why he declined to give the restraining order or to extend it. So, now, reading this, I suppose you could come up with 2 or 3 different interpretations of this, all of which, I don't know, it depends on who's looking at it. It depends on who's considering it at the moment. It could have been any one of different interpretations. So, in other words, what I'm saying is that we're all crazy. We're all crazy here. This man, after leaving the courthouse, after being rejected, goes home, which happened to be a block or 2 from the courthouse, and he tells his mother that it was denied, they're coming to get us now, they're gonna kill us. The sister comes in, talks to the mother, and I don't know who to believe on this, but what did happen was that he shot his sister, because he thought at that time the sister was doing something to the mother that she should not be doing.
Well, there's one fact I think you've omitted. He went and got the gun out of his car.
Yeah, and that he didn't go get the gun out of the car because he knew, well, let me put it like this. He saw them when he went to get the gun out of the car. Now, a question in my mind is, when he went outside and saw them standing on the corner, is that when he decided to get the gun out of the car? Or did he go get the gun out of the car and then he saw them standing on the corner? I don't know. But in any event, you're right. He went, got the gun out of the car, and went back into the house. He did not go immediately up to the corner where they were. And this leads me to believe that he went and got the gun and brought it in the house, believing, as he told his mother, that they're coming to get me. Now, that's my interpretation, and, of course, it's from reading the transcript a couple of times, and I suppose each time you read it, you can come up with another interpretation. But in any event, getting to the real nitty-gritty here, after shooting his sister, he walked up to the corner. Now, most of this comes from his own testimony, which was read into evidence from the previous trial. His testimony about what he perceived at that time. He saw his sister-in-law reaching in a bag. He told her, "Don't do that. Don't do that." He thought she was reaching for a gun. He continued to reach. He shot her. Then he sees his brother reaching into his pocket, and he testified, I thought he was going for a gun, and he shoots him. But then he calmly turns around, walks back to his house, and on the way he passes by a worker, I forget what the worker was doing now, who got scared and was about to run, and he told, no, don't worry, I got no problem with you. Then he goes into the house. I don't know what to make of this except to say that something is wrong with this man, and whatever it is, should the jury have been allowed to consider it in determining whether or not there was reasonable provocation. Now, during the course of preparing for arguments and instructions and all of that, trial counsel requested an instruction on manslaughter based on reasonable provocation and expressly denied that self-defense played a part. She said she was not asking for a manslaughter charge based on excessive force and self-defense, but as I read the transcript, it occurred to me that perhaps it should have been, because if he approached his brother and his sister-in-law believing that they were going to do him harm, and they make a move towards something that he thought was getting a gun, do we have to wait to be fired upon before we can exercise self-defense? I don't know. And I don't mean to be facetious here, but I think back to the old, well, whatever is true, gunfight at OK Corral when the Earps and the Clantons shot it out. I don't think anybody really knows who fired first. But is it necessary? I do know that the Earps were later found not to be responsible because they were acting in self-defense. But who knows who fired first? So is it necessary to act in self-defense for the person that you kill, for them to fire first? I don't know. And quite frankly, I'm glad I don't have to know. I think that's what you'll tell me at some point in the future.
I take it that was there a request at the second trial? So you have lack of criminal responsibility, but as an alternative, mental impairment?
That was a request for an instruction on mental impairment, yes.
And then was that from first to second, or was there a request that it go to manslaughter?
No, the manslaughter, yes. He asked the judge to instruct on manslaughter.
On the basis of mental impairment?
Well, no, on the basis of reasonable provocation. And I connected reasonable provocation with the mental impairment.
So we asked for voluntary manslaughter, not involuntary manslaughter.
Yes, that's correct. That's correct, yeah.
Now, one concern I have is that if you're right, then every person who's paranoid can't be found realistically guilty of first or second degree, because the Commonwealth's never going to be able to prove beyond a reasonable doubt that a paranoid person was not in fear.
Depends on the evidence. But then I'm saying that here, let's let the jury determine whether or not there was reasonable provocation based on the fear that he's going to be killed, based on the fear that the brother was out to get him. Let them make that determination. And if the jury, well, let me put it like this. I can recall trying several cases in front of Judge Barton, and I would come up with some crazy request for instruction to the jury, and he would say, I'm going to give this because, you're crazy too. And if they buy this, they're crazy, so I'm going to give it. So I'm not going to give you an appealable issue, so, on something as ridiculous as this. And reading this transcript, I thought back to those days and said, maybe he was right, because in each case the jury found him guilty, and there was no issue on appeal based on the failure to give this crazy requested instruction. That's called lawyering, so it happens most of the time. But let me leave that, because I think you understand where I'm coming from. The questions that have been asked certainly indicate that you have a grasp of this situation. And move to the second argument, which asks this court to exercise its authority under 33E and reduce the first-degree conviction down to second. I, quite frankly, have never seen a situation like this. I don't think one has ever existed. A defendant shoots two people almost simultaneously. The jury comes back as to one person and says, this shooting was done with deliberate premeditation. But as to the second one, then it is just an intentional killing with malice. I quite frankly have a hard time understanding how that could be.
Well, if you, I mean, doesn't the evidence, though, suggest that there was a long-burning dispute and up to hatred of the brother, but maybe not affecting his wife?
Well, I don't know. I don't know how he felt about his wife, but I know he shot his wife, bang, and then he turned within the next minute and shot his brother because his brother had his hand in the pocket and he told him to take it out. So I don't know. I can't answer that directly. Yeah, but even as you suggest, the long-standing feud or whatever, it's kind of difficult to understand how you can shoot one person and it says that's with deliberate premeditation, and then a person shot 5 seconds later, you say is simply an intentional killing with malice. It seems
That's
like
actually the other way around, right?
well, no, he shot the wife first.
But wasn't that the second degree?
That was the second degree.
Yeah.
That was the second degree. Yeah. So I'm asking you to consider this under 33E. I know there have been some weird situations presented to you for consideration under 33E, and perhaps this is the most weird one of all. I don't know. But I'm asking you that based on what happened there, that you exercise your authority and reduce the verdict. Thank you.
Thank you, Mr. Davis. Good morning, Ms. Glenn.
Good morning, Your Honors. Marguerite Grant, Assistant District Attorney from Middlesex County on behalf of the Commonwealth. Even taken in the light most favorable to the defendant, the evidence here was not sufficient to create a reasonable doubt that some action of Warren or Mary Beranger triggered a sudden loss of control in the defendant that caused him to shoot them each twice in the head before he had time to cool off. The evidence of the Warren Beranger owning a gun decades before, of yelling at the defendant decades before, of arguing with him weeks before, of supposedly threatening him on October 3rd, I'll beat you until you're dead, was not reasonable provocation, nor would it have, there would have been time to cool off. The evidence of what happened at the restraining order hearing, of which this court has a transcript in the supplemental record appendix, it was not evidence of reasonable provocation. The defendant told Lieutenant Hussey and testified at the first trial that after he went outside and got the gun from his car, brought it to his house, shot his sister Patty in the head, he then took the gun and brought it out to the street corner to confront the victims, Warren and Mary Beranger, to try to talk some sense into them. And I submitted a 16L letter, but I'm not sure if my submission may have been recent enough that the court may not yet have it, on the Mercado case that came down a couple of days ago in a similar fact scenario, but in the context of excessive force and self-defense. Similarly here, the defendant had reason to believe that the victim was not armed because they had just come from the Cambridge courthouse, and the defendant and anyone going into the courthouse had to go through metal detectors. So the defendant had no reason to think, based on the fact that the victim had owned a gun decades before in California, that he was armed that day. It's also similar to Commonwealth v. Clemente on that point, and Commonwealth v. Vick, that when the defendant brings a gun to the scene of a intended confrontation, that he can't then avail himself of reasonable provocation. And the evidence about whether or not the two victims were reaching into a pocket or a purse, in the light most favorable to the defendant, the evidence is inconsistent. The defendant told Lieutenant Hussey that Mary Beranger's hand was in her purse. He testified at the first trial that she was merely reaching for the purse. whichever way you construe it as being in the light most favorable to the defendant, that's not enough. And similarly, as to the Warren Beranger, the defendant told Lieutenant Hussey that Warren's hand was in his front pocket, but yet he testified at the first trial that he was reaching toward his back pocket or his belt. And either way, however you think of that in the light most favorable to the defendant, it is not a circumstance that would that would amount to reasonable provocation. And the reasonableness of the provocation has to be both objective and subjective. And the court in Rivera rejected the idea of thinking of it only from the defendant's irrational point of view, and also the model jury instructions dictate that the court should look at it from the point of view of a reasonable person. As far as the 33E argument, I would call the court's attention to the McNichols case that I cited in my brief. That was a case that I did find where there were both first and second degree murder convictions. I can't remember right now how close in time or what the causes of death were, but the court affirmed on 33E review, even though one victim's death amounted to a conviction of only second degree. And I would also, as long as we're on the subject of Judge Barton, call the court's attention to Commonwealth v. Barnowski, where 2 victims were shot in the head, and this court held that fact alone was grounds not to warrant 33E review. Unless the court has any further questions, I will rest on my brief.
Thank you, Ms. Grant.